The first issue that needs to be addressed is whether Franklin, Shelley, and Ruby are jointly liable for breach of trust. In tackling this issue, we must understand the concept of breach of trust and its categories. So in concept, a breach of trust is a liability imposed on trustees for both an act or omission, which is failure to act, of the trustee in carrying out the duties imposed on the trustee by the trust deed or by law. So a trustee violates trust when he fails to perform his duties properly or exceeds his power. So breach of trust was broadly defined in Yu Yang Property Limited and Minter Ellison Morris Fletcher as falling into three categories, namely merely imprudent exercise of power, for example, power of investment by failure to employ the care and diligence which equity requires. Second, the liability for breaches of trust causing loss to the trust estate. And third, breaches of fiduciary duties of loyalty and fidelity. Spencer must prove that there is a liability imposed on trustees for both an act or omission of these trustees, namely Franklin, Shelley, and Ruby, to execute the duties imposed on the trustee under the trust deed or by law in order for Spencer to bring action against Franklin, Shelley, and Ruby for breach of trust. So, Franklin, Shelley, and Ruby may be held accountable for breach of trust if they fail to carry out their responsibilities properly or exceed their power. So, as per the case of Yu Yang Property Limited and Minter Ellison Morris Fletcher, Franklin, Shelley, and Ruby may be liable for breaches of trust causing loss to the trust estate, which is the second category.
On to the next part of the law. According to Section 35, Subsection 1 of the Trustees Act 1949, in essence, it is stated that a trustee shall only be answerable and accountable for his own act only and not for any other trustees unless the same were to happen through his own wrongful default. Therefore, a trustee shall be protected and innocent under Section 35, Subsection 1, where another trustee is liable of breach unless his own willful default caused that breach. And if there was willful default, he will be liable and sued jointly with the other co-trustees in breach of trust. This is affirmed in the case of Townley and Trevon decided in 1633 J. Breach 25, where it was held that a trustee is personally liable for their own breach of trust. Therefore, nevertheless, the trustee's duty is to administer the trust jointly with other co-trustees unless provided otherwise. And therefore, if there was failure to do so by willful default, he will be liable and sue jointly with the other co-trustees' act of breach. This is affirmed in the case of Bryce and Stokes, decided in 1805 32 All ER 1111, where a trustee is liable for the co-trustees act, where the trustee himself is a passive trustee or allow a trustee to have sole control over the trust property, or where they do not act to prevent a breach, or where there is a collusion or concurrence on the trustee's part. To apply the law, generally, the trustees, Franklin, Shelley, and Ruby are personally liable for their own breaches as per Section 35, Subsection 1 of the Trustee Act 1949, and this is also established in the case of Townley and Sherman. However, the duty to administer the trust is a joint duty among co-trustees. Therefore, failure to do so, either being by a passive trustee or allowing the trustee to have sole control over the trust property, or failure to prevent a breach, or where there are concurrence or collusion among the trustees' parts, will make them jointly liable for the co-trustees' breach as per the case of Bryce and Stokes. Next up, in the case of Haji Ali bin Haji Muhammad Nur deceased, Hafsa binti Nasira and another, and Muhammad Zain bin Haji Ali and others decided in 1933 to MLJ 135, hereinafter as the case of Haji Ali. There were three trustees, namely A, B, and C. A was a semi-literate woman who knew little to nothing about business matters, and B had committed various breaches of trust. In most matters relating to the management of the estate, B had consulted C, an elderly, successful businessman, and obtained the latter's opinion. C had also seen the accounts kept by B and were satisfied with them. The court held that A, who was the semi-literate trustee, had in fact acted reasonably and honestly and ought to be fairly excused, but not C, who was a literate and business-minded person, but was a passive trustee, and therefore he was jointly liable with the defaulting trustee B on the facts and on the court's judicial discretion. In the case of Said Muhammad Al-Sagaf and Roland J. Ferrer, decided in 1934 in SSLR 347, it is stated that a passive trustee who stood and do nothing while his co-trustee dissipated the trust property would generally not be excused of liability from the courts. To apply the law, Shelley is a businesswoman who often goes to the United Kingdom to manage her business there, and furthermore, according to other beneficiaries, Shelley being always away for business abroad, allowed Franklin to have full control over the trust property, and therefore it can be said that Shelley is a passive trustee. And by virtue of the case of Haji Ali, Shelley will be held liable for the breach of trust committed by Franklin, as she is literate and business-minded, and it could not be said that she acted honestly or reasonably as a trustee. And therefore, as per the case of Syed Muhammad Asagov and Roland J. Ferrer, Shelley, being a passive trustee who merely stood and do nothing while letting Franklin, her co-trustee, dissipate the trust property, will not be excused from liability. Therefore, the protection under Section 35, Subsection 1 of the Trustees Act 1949 shall not apply to Shelley, and she will be jointly liable for Franklin's act. On the next part of the law, it is stated that a trustee may be liable after his retirement for a co-trustee's breach of trust if he retires with the contemplation, or in other words, foresaw or reasonably foreseen that a breach would occur, and that he made his retirement to avoid his involvement to the breach, or where he retired with the intention to facilitate a breach. In the case of Head and Gold, decided in 1898, 2ch 2050, the court held that for a retiring trustee to be liable for breach of trust committed by his successor, it must be proven that the breach of trust committed was not merely the outcome of the retirement or appointment, but that the former trustee had contemplated it before the retirement and the new appointment took place. For the application, a retiring trustee, namely Ruby in this situation, would generally not be liable for the breaches of other trustees after her own retirement. However, this is only so if she retired without any contemplation of a breach or without any intention to facilitate a breach. However, it can be seen that Ruby resigned from being a trustee in July 2021, which is 1 month before Spencer found out about Franklin's breach of trust, which was in 1st August 2021. And besides that, according to the other beneficiaries, Ruby knew and somewhat expected what Franklin was about to do, but chose to retire to avoid her involvement in that matter. And therefore, Ruby must be held to have contemplated such breach and retired to avoid liability. And applying the case of Head and Gold, Ruby will be jointly liable for Franklin's breach of trust, as she had contemplated it before the retirement took place. Moreover, briefly, Ruby is a retired school teacher who spends much of her free time tending to her garden, and as per the facts, the trust is mainly managed by Franklin, and therefore she is a passive trustee doing a trusteeship, and furthermore, she is literate, being a retired school teacher. Hence, by virtue of the case of Haji Ali, Ruby cannot be said to have acted reasonably and honestly as a trustee. Therefore, Ruby is not entitled to the protection under Section 35, Section 1 of the Trustees Act 1949, and therefore she will be jointly liable for the breach of trust committed by Franklin.
As per the case of Bahin and Hughes, the trustees are under a duty to act jointly and anonymously. In principle, each trustee has an equal role and standing in the administration of the trust. Accordingly, if a breach of trust has occurred, each trustee is equally liable, or the trustees are collectively liable to the beneficiary. Thus, the liability of the trustees is joint and several. The innocent beneficiary may sue one or more or all of the trustees. However, in the case of Target Holdings Limited and Red Funds, it was decided that a trustee will be liable in a situation in which the breach of trust has caused some loss to the trust. There will be no liability in respect of a breach of trust where that breach resulted in no loss to the trust. So it was further emphasized in the case of Nestle and National Westminster Bank Public Limited Company that a breach of that duty is not actionable and thus irrelevant if it does not cause loss. So as a result, a claimant who cannot demonstrate what a loss is in that sense was caused by a breach of duty, it will fail in this claim. Franklin, Shelley, and Ruby's liabilities are generally personal. However, according to the case of Bahin and Hughes, Franklin, Shelley, and Ruby have an equal role and standing in the trust administration. So as a result, the trustees' liability is joint and several. So in that sense, Spencer has the right to sue any or all of the trustees. And according to Target Holdings Limited and Red Funds, Franklin's actions in withdrawing 250,000 ringgit from the trust account and depositing the funds into his personal account resulted in a direct loss to the trust. But on the other hand, both Shelley and Ruby's failure to act reasonably and honestly had resulted in the loss of trust. Since there was a loss to the trust, therefore, as per the case of Nestle and National Westminster Public Bank Limited Company, Spencer can bring action against Franklin, Shelley, and Ruby. In conclusion, Franklin, Shelley, and Ruby are jointly liable and severally liable for breach of trust. Therefore, Spencer may sue one, more, or all of the trustees.
Moving on to the second issue is on the defense of trustees. The issue is whether Franklin may invoke any defense for the act that he committed against Spencer. Regarding to the defense of trustee, the Trustee Act of 1949 contains two provisions for a trustee to invoke, which are Section 63 and Section 64. Section 63 discusses on the power to relieve the trustee from any personal liability, while 64 is on the power to make the beneficiary indemnify for the breach of trust. Section 3 reads as follows. Based on the provision, these are the main takeaway from the statute. A trustee must prove that they have acted honestly and reasonably when they have committed a breach of trust. If they can prove such a thing, the court may relieve them from their liabilities, either wholly or partly from the personal liability. However, the current provision may not be relevant as the next provision, because in this case, it is clear that Franklin had committed the breach with clear intention and did not act honestly. Moving on to Section 64, it reads as follows. Mainly, there are three things that must be proven by the trustee. The first is that the trustee must prove that the beneficiary had consented to the act of breach. Consent from the beneficiary must also be a valid consent and had been clearly communicated. The beneficiary must also be full of age, sound mind, and the beneficiary must also have the full knowledge and the relevant facts to exercise an independent judgment. Thus, in the case of Somerset, the court will not exercise its discretion under Section 64 unless the beneficiary was aware and had understood all of the relevant facts that resulted in a breach of trust. Or, in other words, the trustee must prove that the beneficiary was aware of the breach, and in order for the court to allow the use of Section 64. Also, in the case of Stafford against Stafford, a trustee may invoke Section 64 depending on the beneficiary's conduct after the breach. If the beneficiary's conduct showed any hesitation in taking action against the breach, it would be sufficient to protect the trustee from being sued by the said beneficiary. Silence also amounts to an acceptance according to contract law. However, in Fletcher against Collis, 1905, it was held that it is not necessary that the consenting beneficiary has benefited from the breach of trust. Breach will not affect the right of the other beneficiaries who did not consent to it. Therefore, beneficiaries who have not consented to anything may take action against the trustee. Thus, to recap the law, Section 64 may only be invoked by the trustee if the beneficiaries had consented to the breach. The consent is only valid if the following are satisfied. However, as in the case of Fletcher against Collis in 1905, non-consenting beneficiaries may not be affected by the consent of the other beneficiaries, giving them the right to sue the trustee. In application to the current case, Franklin may invoke Section 64, verse subsection 1, against the other consenting beneficiaries. As according to the facts of the case, the beneficiaries were aware that Franklin has been moving funds from the trust to his personal accounts and had spent it for his personal use, making the consent valid as seen in the case of Somerset. He may also apply Stafford against Stafford because the beneficiaries had in fact was reluctant in taking action against him. Thus, the beneficiaries who has consented are barred from taking any actions against Franklin. However, Spencer has the right to take action against Franklin by way of the case of Fletcher against Collis. This is because Spencer had not consented to the breach. Given the fact that Spencer is only aware of the current situation and is interested in taking action against Franklin, Spencer may be able to do so. Thus, Franklin may not invoke the defense of Section 64, subsection 1, to protect himself from Spencer's possible legal action. In conclusion, Franklin may not be able to invoke any available defenses to protect himself from Spencer taking any action.
Okay, so the third issue is whether Spencer, as one of the beneficiaries, can rely on the remedies of trusting to recover the trust money from Franklin. The judge in the case of Boscawen and Bachua defined trusting as the process by which the plaintiff traces what has happened to his property, identifies the person who has handled or received it, and justify his claim that the money which they handle can properly be regarded as representing his property. In the case of Foskett and McEwan, Lord Miller stated that the beneficiaries would be able to trace the trust property because of their equitable rights in the property, and if the beneficiaries succeed, they would be entitled to the remedy. So, there are three rules that must be satisfied for equitable tracing. Firstly, there must be a fiduciary relationship. The remedy of tracing cannot be made possible unless, at first instance, there exists such a relationship. So, the court ruled in the case of Sinclair and Braham that a fiduciary relationship is necessary in order to trace in equity. In applying the first element, there is an existence of fiduciary relationship between Franklin and Spencer, whereby Franklin has been appointed as the trustee for the benefit of the beneficiaries. So, by referring to both cases, through Diplock and Sinclair and Braham, it can be seen that the trustee-beneficiary relationship is established. Therefore, the first element of equitable tracing is fulfilled. The second rule that must be satisfied is the property must still in a traceable form. The general rule is that the property must be traceable because if there is no property to trace, then the right is lost. For example, if the property or the money was spent on services rather than goods, the property is deemed to be dissipated and hence it can no longer be traced. For this condition, it can be applied in two situations which are unmixed fund and mixed fund. The relevant situation for this question is mixed fund. Okay, so mixed fund can be defined as when the trustee mixes trust money with his own money into his personal account. So, in the case of real estate, the court said that where trust money has been mixed with the trustee's money, the beneficiaries can no longer elect to take the property because it is no longer bought with the trust money simply and purely, but with a mixed fund. However, the beneficiaries are entitled to put charge on the property purchase. There are 4 situations provided for mixed fund as stated in the slide, but the one that will be discussed is the rule in Dree-Oath way. In this case, the court preferred a sophisticated analysis and refused to allow the trustee in breach to have priority over the beneficiary's claim. In this case, the principle is that when mixed funds happen, the trustee's account has been exhausted first by withdrawals to acquire assets. Next, by withdrawals which are dissipated, for example on living expenses, a holiday, the tracing will become physically impossible. The facts of this case are as follows. In applying to the second rules, we can see that the only property that can be traced back is the 100,000 withdrawn by Franklin to invest in a unit trust in his own name. According to the Dree-Oath's principle, the unit trust can be traced back and the beneficiaries is entitled to it. Spencer is entitled to an equitable charge on the unit trust which worth 100,000 for the 250,000 trust money and interest. However, it was stated in the question that the unit trust value has increased to 145,000. Hence, by referring to the case of Hayton and Marshall, Spencer can claim the 145,000 and he can also make a personal claim of 150,000. Therefore, Spencer can end up with 145,000 worth of unit trust and a claim of 150,000 against Franklin. Moving on, in regards to the money 50,000 ringgit withdrawn by Franklin to pay down payment in a house for his family, it should be considered as dissipated. However, as the house has become his property because by paying down payment, it indicates that he has owned the house, hence Spencer can put a charge over the house. Next, we shall look at the trust money used by Franklin, which is the 30,000 ringgit, where he spent it on family vacation in Paris. The money he spent has been dissipated and can no longer be traced back. And lastly, on February 2020, Franklin has donated 20,000 ringgit to a children's home in his hometown to help finance a much-needed renovation of the home. So, according to the Dree-Oath way, the said trust money will be considered as dissipated and also can no longer be traced back. Lastly, the third condition of tracing is there must be no inequitable results. By this, it means that the tracing will be not granted by the court if it causes an inequitable result which causes an injustice. This can be applied in cases where it involves an innocent third party or volunteer. In Diplock, the court stated that in a situation where a volunteer already owns the property but the trust money has been used to renovate or improve it, then it is inequitable to charge the property because it will be inequitable to ask him to sell it after all the property is originally belonged to the volunteer. In applying to the third rules, it can be said that there is no third party involved. The transaction of 100,000 ringgit withdrawn by Franklin to invest in the unit trust will not cause any unequitable result as it does not involve any third party. Besides, the act of tracing the house purchased by Franklin does not lead to an inequitable result, as it can be assumed that the house was registered under Franklin's name. Therefore, the last element has also been met. In conclusion, Spencer can only recover the trust money used to purchase the unit trust by Franklin, a personal claim of $150,000, and he is entitled to the money obtained through the sale of Franklin's family house, where he has put charge over it. Meanwhile, the money 30,000 ringgit and 20,000 ringgit, in which Franklin used to spend it on a family vacation and help finance the renovation of the children's house, is deemed to be dissipated and can no longer be traced back.